Very much, Paul, and welcome back everyone in the room and the many people online. So I'm Irit Mevorak, Professor of International Commercial Law at the University of Nottingham, and I'm really delighted to introduce this final presentation of this very interesting day. Thank you, Paul Bannister and the Insolvency team for organizing it, for bringing all of us together today, and to Nottingham Trent for hosting us so brilliantly. So this session will be a presentation by Dr. Stephen Baister on the assignment provisions that were introduced into the Insolvency Act in 2015. Dr. Baister is a non-executive director of Manolete Partners, a consultant at Wedlake Bell, a mediator at Three Stone Buildings, and he also sits as a deputy Insolvency and Companies Court judge. He's also honorary president at the Chartered Institute of Credit Managers, and he has written on various insolvency issues for a variety of books and journals. So as I said, he's going to speak about the assignment provisions in the Insolvency Act. He has a proposal to make in this respect. See if you're persuaded or if you have any comments or questions. Dr. Baister told me that he has also shortened his presentation further during lunch so that there will be more time for questions. So
to get home early, I hope.
And to get home early. So over to you.
Thank you very much, Irit. I mean, when I heard Mark Austin introducing briefly my paper this morning, I think it might have given the impression that it had some intellectual content, but I can assure you that my aim is to end this conference on a low note with with an absolutely basic practitioner point. I should also say there are no slides, which at least means there's one thing I can't get wrong. The title, A Thing That Has No Value Does Not Exist, comes from a 1991 novel called Lila, An Inquiry into Morals, by a generally forgotten American author called Robert M. Pirsig, who's better known in my generation. I can see a nod over there from another old guy. A novel called Zen and the Art of Motorcycle Maintenance. It can obviously mean many things, that quote, but to me what I'm getting at is that a cause of action in insolvency, like any other asset that can't be realized, obviously has no value. It's no good to the creditors. And I go on to suggest, as Irit has foreshadowed, a way in which value can be given to assets. Now, that was recognized, as you rightly said, in 2015 by extending the ability to assign to include, under Section 246ZD, a number of office holder causes of action, and I'm going to cut down by not explaining what they are because I think they'll be familiar to everybody in this audience. The mystery to me is why, when that section was brought in, it was not automatically extended to bankruptcy, and that's going to be my first port of call. And then I'm going to ask why it wasn't extended to other causes of action, more broadly outside bankruptcy. And in some cases, I'm going to suggest that it would be good to make explicit that certain other causes of action can be assigned. I'm going to explain why I think they can, but I know not everybody agrees with me, and I think it's a good idea to wrap that issue up at the time. So my first proposition is that Section 246ZD, or a corresponding section with a lot of letters after it, should be introduced to provide for exactly the office holder causes of action that mirror those in the corporate section to be assignable in the same way. They probably wouldn't be as significant in numbers, but I think they could be significant in impact. And of course, there are still large bankruptcies around where it might make it worthwhile. Now, I could stop there, actually, and you could really go home and we could all have another pint. But I think in deference to this occasion, I should probably flesh out those ideas just a little bit. I begin, obviously, with the functions of the office holder. They're well known. Duty of a trustee in bankruptcy is to realize, distribute the bankruptcy estate, pay the expenses of the bankruptcy and the bankruptcy debts in the order laid down by the 1986 Act. And that very simple quote comes from an old authority, but there are loads to similar effect, and I don't need to go on about them. The second principle I just want to mention briefly is that of the office holder as a fiduciary. Most recently, and I think most thoroughly explored in that case, Mirror versus Maxwell by Mr. Justice Ferris, where he had a look at the nature of the office holder's fiduciary office in some detail. And again, I'm going to skip over that because most of you will be well familiar with it. I'm just going to concentrate on one short passage where he referred to, in that context of the fiduciary obligations, the realization of assets as having to be in the most efficient way so as to obtain the highest possible price for the assets, and the winding up or other process should not be unnecessarily protracted. So I'm just focusing on the good value, efficiency, non-protraction. The ability of an office holder to fulfill that duty in relation to the assets, it seems to me, is assisted best by the widest possible market for those assets. I mean, one of the cases we've heard about today illustrates, I imagine, an asset that's not going to realise very much because of the problems attendant on it. There's not much of a market for power stations, I imagine. But if you think of the normal asset, the greater the market, the greater the possibility of the manners of disposing of it, the more likely you are to assist the office holder in that important part of performing his or her duties. So my suggestion is that my proposal chimes in with that in the sense that it would widen market, and that's consistent with the duties I've outlined, both fiduciary and in terms of realization. The policy, I've cut out a big section here because I was going to go to a judgment of Mr. Justice Snowden, as he was, in Cage Consultants, a case more commonly known as Reed Total Brand, where he looked in a very, very strange context at the background to the thinking about the whole policy of assigning or introducing the section. As I say, I'm going to skip over it because you can read it yourself. A lot of it's in government documents that are widely available anyhow. But again, I simply focus on one small passage where he emphasized the policy behind the introduction of the provision as enabling creditors, unsecured creditors in particular, to benefit from the proceeds of sale of office holder claims, which he said would be more likely to be pursued now that the sections come in. And I think that's undoubtedly true. And again, I would say that applies as much in bankruptcy. Now, I had a quick look at the government documents, and I can't find at any stage, Paul may help me on this later or he may not, why bankruptcy was not considered or why it was excluded, but that may be a deficiency in my reading. It may just have been, well, let's just do this and see what happens. I don't know. So anyhow, whilst Mr. Justice Snowden and those documents give reasons for concentrating on certain corporate provisions, that question still remains. Why not bankruptcy and why not other things? Because the simple proposition for bankruptcy is what's sauce for the goose should be sauce for the gander, the goose being bankruptcy, I think, and the gander being corporate insolvency or the other way around. Curiously, there's a long history of an ability to assign in bankruptcy. There's an 1880 Court of Appeal decision which approved assignment, a case called Sear versus Lawson. It has been referred to. It started to pop up recently, I think largely because I've been nudging it around the place. At least I like to take credit for it, which indicates there's actually a much longer history in bankruptcy of an ability to assign that might think that's 19th century reported case. Bear in mind there might be a lot of other unreported incidents knocking around there, reporting having been rather sparse in those days as opposed to reporting of everything everybody says about anything nowadays. But in any event, the Court of Appeal held in that case, Sears versus Lawson, that an assignee was entitled to continue an action that had been assigned by a trustee in bankruptcy. Let me move to a few non-bankruptcy issues and posit some propositions that may not find favour about other provisions relating to insolvency that I think are capable of assignment. The first, which is rather controversial, is void transactions. Now it's often thought that a void transaction is an office holder claim, and that goes back to Riayala Holdings, a case from 1996, which in turn rested on one of the MC Bacon cases. And in that case, the court, I think it was Mr. Justice Knox, chucked out an assignment by a liquidator of the cause of action on the basis that it was an office holder cause of action and wasn't therefore in those days, pre the section I'm talking about, capable of assignment. And I think, with great respect, that's got to be wrong for a couple of reasons I'm going to now very briefly suggest. I've developed it at some length, but I'm not going to keep you from the pub with it all. The basic propositions are these. We know from a lot of the authority that 127 void transactions doesn't create a separate cause of action, and there's a lot of authority that says you go back to the general law and that the general law is restitutionary in nature. And there's a big argument then about whether we're in Goff and Jones sort of big restitutionary territory, but I think these days it's been narrowed down quite a bit thanks to an excellent judgment of His Honour Judge Paul Matthews in a case called Office Serve Technologies Limited, where he did a very thorough review of the existing authorities and came effectively to the decision that it was restitutionary, but in a very, very specific way, in a very restrictive way. So you don't go through all the ghastly business of having to prove all the elements of unjust enrichment and so on. Basically, it's what we've all thought it always was, which is you give back that which you've had. And I think that's an immensely helpful judgment. But if the remedy is restitutionary, to whom or to what is the restitution being made? Now, logically, to me, it can only be to the company, because it's the company that's been deprived of its underlying assets. It's not the office holder. It's different in bankruptcy, where the estate's vested, so it's the estate vested in the trustee that's been deprived. In the case of a company, it is the company that was deprived at the relevant time, and of course the company still exists. Now, if I'm right about that proposition, which I'd happily debate on another occasion, and I do appreciate it may not find favour with all of you, if I'm right about that, and it is fundamentally the company's cause of action, then it must, of its nature, be assignable, at least in corporate insolvency, not necessarily, of course, in personal insolvency, where the estate will have vested in the trustee. But that can be quite easily overcome by taking up my first suggestion and making all the bankruptcy causes of action available to an office holder assignable as well. Let me move on to transactions in fraud of creditors. They're a bit of an oddity. We haven't mentioned them today. Section 423. And of course, it's only a semi-insolvency remedy, really. Although it's in the Insolvency Act, it's available, as we know, to victims, widely defined, anybody who can have fallen foul of the effectively the desire in forming an earlier transaction to do the creditors down in some way. Now, I'd argue that because whoever's bringing a 423 claim is in fact the victim or in the same position of a victim, that person is not necessarily an office holder or is an office holder in a particular position as a victim, and ought therefore to be able to assign that cause of action too. But one of the things we know about this area, which is whether you're dealing with CFAs or assignments or anything to do with funding, is there's been an enormous amount of satellite litigation over the years. I mean, a few years ago it was focusing, I think, Francis, you'll remember, on CFAs, where everybody was attacking all those endless regulations and the procedures involved. Recently, I know, the assignment's been under attack as well, and so far has survived quite well. So although I'll say, for the reasons I've given very briefly and not very well developed, I accept this afternoon that a Section 423 cause of action is also capable of assignment, what I would suggest is that if I can persuade the Insolvency Service to look at this and to bring in a reform, one of the things it might not be a bad idea to do is to clear these areas up and make explicit what is not explicit at the moment, which is that these causes of action too are capable of assignment. It might not be a bad idea to look at Section 212 as a procedural gateway as well. Again, I accept there's controversy about that because of its procedural nature rather than its substantive nature. But is there any reason why, for example, on an assignment, that shouldn't be available to an assignee in the same way as an office holder? Now, there are arguments against that, and I always counter them by pointing out that an assignee can always get around the provision anyhow by becoming not a contributory. That's not going to be an attractive proposition, or possibly not even a possible proposition, but by becoming a creditor. You buy a quid, and you're in the section that allows you to use Section 212. You simply become a creditor and you avoid all that trouble. So again, there are strange anomalies there that I'd suggest it will be worth ironing out by making it explicit that an assignee of say, a company cause of action, as it usually is, could also become the assignee of the office holder's cause of action and invoke the same procedural gateway to the extent that it's necessary. And of course, very often the reality is that it isn't. There are a few other oddities as well. I mean, it's very hard to know where you stop when you start on this. So let me mention Section 214A of the Insolvency Act, not one much read. It's all to do with the adjustment of withdrawals and the winding up of a limited partnership. And I didn't know about it, but somebody nudged me about it the other day, and I looked it up, and it is there. And I don't really know what it's about. But for example, it must be an office holder cause of action. Why not make it assignable? I don't think anyone's going to be making a lot of money out of it, frankly. But picking up on Stuart Perry's point earlier, why shouldn't Section 216, 217 actions be assignable? I hadn't thought about it until you raised it today, Stuart, but maybe they're assignable in any event. I don't know. I hadn't thought about it, as I say. But again, why not wrap all these things up? And that really brings me to what's going to be my closing point, I hope roughly on time, which is, although I've gone through little its and bits and suggested that there's possible room for reform there and a way of ironing over some glitches, which obviously I've papered over because I haven't got a long time to deal with it today. I suppose the simple proposition at the end is, why not make anything an office holder can do, whether as agent or in his or her own capacity, capable of assignment, precisely with a view to widening the market that I talked about at the beginning? And at that point, I think I'm going to stop, if I may.
So a spectrum of proposals to me seem quite sensible, but I haven't thought about it before, and I wonder whether there are any underlying problems and it's not as simple as it sounds. I don't know. Let's hear from others. So any questions or comments, and I will also check the computer. Yeah.
Thanks, Kev. Simon from the Policy Unit. Just on you mentioned about why didn't we do bankruptcy at the same time as we did the corporate stuff. There's actually quite a straightforward answer to that. It was the work we did then was part of a much bigger package that BEIS were pursuing. I think it was called Transparency and Trust. Yeah, that's all right. I got that the right way around. Always go. Yeah. So it was a Transparency and Trust project, and that was specifically about corporate responsibilities. There was lots of stuff in the Small Business Act that wasn't insolvency related, but we did do some insolvency stuff which included ways that we could get money back to creditors where there had been wrongdoing, and so that they were brought in at the same time as compensation orders and undertakings and assignment of office holder claims. So it was part of a bigger corporate package. So that's
interesting. I'm grateful for that piece of information because I couldn't find anything about it. What I would say is, of course, that answers my question, but doesn't answer my question.
Fair.
But thank you all the same. No.
Apologies for hogging the microphone. Can I suggest that possibly Section 234 to 236 should be off your list of things which an office holder can do which should be assignable? Powers of investigation, public examination?
Well, I think that's more difficult to justify.
So I think
Yeah, I mean, because, yes, you're rightly correcting me in my very glib closing remark. You're right. When I meant causes of action, I should have said causes of action directed at recovery. You obviously, I accept, could not give the investigative rights available. Yeah, so I withdraw and I modify what I said, and I'm very grateful for that observation. I mean, not that some of those remedies, I mean, after Al-Jabbar and Mitchell, I'm not sure how useful some of the investigatory powers now are. You know, that case about the witness immunity attaching to examinees and so on. So that's a different point. That's for another day.
Any other questions?
If you don't mind, it's me again. Just on things like Section 423, and you were talking about Section 217 earlier. These are claims which belong to people. They're claims that creditors can take if they've incurred further debt from somebody who's breaching 216. I'm not, and 423 again, somebody can seek restitution for damage they've suffered. Why is there any doubt about whether they're assignable? Because if they're actions that are owned by somebody, why can't they be assigned?
I can only say that I have, when I've had conversations with people, they've expressed considerable doubts about whether 423 is assignable when the action is brought by an office holder, because some people have said to me, well, when it's brought by an office holder, it becomes by its nature an office holder action, and therefore falls in the camp of, the sort of proceedings that the office holder couldn't assign, even if another victim could. I'm sorry I didn't develop that terribly well, but, time is lacking. Now, I don't know whether that's right or wrong, and I haven't yet seen somebody try to assign a 423 action. So I simply rely on that simple debating point, coupled with the fact that if, in the unlikely event that in my lifetime somebody takes up my suggestion, in the unlikely event that Parliament would ever have time, but you've got plenty of time to do other things, Paul, I notice, that you're contemplating. In the unlikely event somebody took it up, I just think it wouldn't be a bad idea to clear that up as part of the process, because we all know that insolvency these days is falling increasingly victim of satellite litigation that gobbles up a lot of the assets. Just look at the law reports and compare the amount of time spent on interlocutory stuff that's often time-wasting and not terribly valuable. So it's simply a tidying up exercise or a clarifying exercise that I'm suggesting.
Okay, thanks.
I think there is a market already in 216, 217, because I think you just buy the debt, and so there are pieces of litigation.
As I say, I only thought of it this morning, hearing
already.
Stuart. I'd forgotten about it.
But if you take an asset in an insolvency, say it's a property, you get more bidders, you get more value. I understand that. I'm not sure that it's true in the assignment market, because a huge number of entrants, it seems to me, into the market, and yet the pricing seems to be incredibly similar across the market. And perhaps more assignable things might make that improve, but I think because you can take the top of the market and then you don't have to adjust your pricing, is that giving the best value back to the estate?
Yeah, that could be right. Incidentally, in my cutting out, I forgot to say I should have declared a conflict of interest. I am, as Irit said, I'm a non-executive director of Manolete. It's in here, I promise you. But the point, so we do take assignments, so there is I accept an element of interest there, although I'd say the propositions I'm canvassing are actually of slightly wider concern. It's not just about touting for some business. I think there is a real fiduciary and what have you issue there. But I think you may be right, Francis. Oddly enough, although I do work part-time for a litigation funder, I don't actually know much about the mechanics of the market. You'd be in a better position to know than me what the CFA market is as opposed to the funding market, what the internal funding market is, and so on. All I'd say on that is something I've said many times, that I'd regard it as part of an IP's fiduciary duty in pursuing an action to consider not just the recovery of the asset and you know, all that sort of thing, but the cost, you know, which type of solicitor do you go to? What kind of, how are you going to fund? And to at least undertake some testing of the market before embarking on one particular course rather than another.
No, I agree. I think they should look at what's available and record their decision-making process. I do think the CFA market has tightened because of the availability of assignment, because money is going to the easiest cases, and so that obviously affects the willingness of solicitors to do CFA work. I think that's fair.
I mean, I think the good thing is that that market is becoming not just tighter, but also better known and better explored by insolvency practitioners. So there's not much excuse for not striking a decent deal, I think, in most cases nowadays. Whatever disagreements you and I may have about other aspects of it, I think we certainly agree about the fiduciary duty and the widening market.
Just to mention another concern expressed here online about your more radical idea of assigning anything to
subject to the qualification.
So they say if there is the prospect of assigning any claims to third parties, are we running the risk of negating the role of the IP? Of negating the role of the insolvency practitioner?
Oh, no, I'd say quite the contrary. I'd say it's part of the role of the IP for the reasons canvassed in the discussion I've just had with Francis, to help the IP to do his or her job more effectively by offering more and more possibilities. Sorry, you crept around to that side again, the old age deck. It's not my question. No, it's not your question. I mean, I think that's my simple answer to that.
And I think with that we will end this discussion. So thank you very much, Dr. Bates.
Thank you very much.
And everyone for the question.